and on what ground you can have divorce. So how to separate is also a legislatively regulated provision. So coming to the privacy part, even the codified law amongst heterosexuals protect the privacy of man and a woman inside the bedroom. But there are certain provisions where there is an intrusion to privacy rights also. For example, importance is a ground for divorce. That is something very, very private and personal between the two human beings. But then, if it is a case of divorce, you will have to come out and prove it. So your privacy is breached. The substance of my submission, which I will elaborate, is that once a legislative recognition is given to a particular form of union, it comes with it several regulatory provisions and it is only the parliament, my lord, which can conceive of several situations which would arise in this relationship which is now recognized and can provide for its regulation. It would be impossible for the court to conceive all situations. Now, my lord, my propositions, my lord, I'll just, my lord, one of, my lord, there are 10 propositions, my lord. My lord, the very heart of Special Marriage Act, and I'll show that, is a recognition of marriage between a conventional man and a conventional woman. Your lordships need not, Lord, write, because I have, Lord, in that page 3, my lord, I have, my lord, written them. Second, the request, my lord, and I will demonstrate, my lord, more effectively. The request ultimately is that you please rewrite to suit our situation, which can be done by the parliament. I am not, my lord, opposed to the situation or some regulation coming into place. By whom is the question? And that rewriting would not be possible this also, your lordships need not, my lord, invest, my lord, time or energy, my lord, in writing it. This rewriting is not permissible, not only on the ground that the courts would not rewrite the law or say what the law should have been, but the thing which we are now seeking to achieve, the petitioners are seeking to achieve, was consciously omitted in Special Marriage Act. That is one more reason it cannot be read into it. I'll, my lord, make that submission good. So, my lord, your lordship's exercise would be constrained, my lord, by 4 fundamental principles. One, the court will not change the character of the law. And the character, your lordship, will have to examine from the entire architecture of the act. Read with all allied statutes and the history which preceded enactment of the Special Marriage Act. Second constraint would be the court cannot substitute the legislative intent which is otherwise manifest. And third, your lordships will not, my lord, read words of larger amplitude in place of words of smaller amplitude, namely, person is a word of larger amplitude in place of male and female. Next, my lord, proposition. Lord, this exercise, even if your lordships are persuaded to undertake, would necessarily have an unintended impact on the heterosexual couples, because Special Marriage Act essentially is for regulating the marriages between intra-faith heterosexual couples. But now, I'm sorry. The next proposition is, your lordships would not, my lord, undertake an exercise whereby the same statute is applicable differently to one class of persons and totally differently to another class of persons, namely heterosexuals and non-heterosexuals.
Where the same statute is applicable
to differently to different classes of
So we
persons,
use
my lord, namely heterosexuals and non-heterosexuals.
we use one lens for heterosexual couples and another lens for non-heterosexual couples.
Yes, my lord. And I'm grateful, my lord. I could not put it that succinctly, my lord, but that's the respectful submission. And it would be impossible for your lordships to reconcile this classification. I'll be able to show from the scheme and structure of the Special Marriage Act. Next, my lord. Lord, we are dealing with, let us understand what we are dealing with. Lord, we say LGBTQAI plus. Correct, my lords? We know L stands for lesbians, G for gays, B for bisexuals, T for transgenders, Q for queers, I for intersex, A for asexual. Look, we have not tried to know what plus means. And my lord, this is going to be the core of the problem which your lordship would face if the judiciary were to take over the function of regulating the relationship after recognizing it as a socio-legal relationship. Lord, there are 72 shades or variations. That is why, my lord, what we write is plus. And please examine, my lord, how your lordships would, even if your lordships are persuaded to, my lord, kind of undertake an exercise of rewriting, Lord, deal with these varieties of situations. My lord, please allow me to place, my lord, that, my lord, at page. I'll just, my lord, give some examples to, my lord, annexure A, page 109.
of what, Mr. Solicitor?
My lord, of my written submissions, my
Let
lord.
me just go to
Lord, my lord Justice Paul, my lord, has my written submission.
Yes, yes.
Written submissions. There are several different shades and spectrums, my lord. It's not that we are dealing with either lesbians and gays and transgenders. We are dealing with, my lord, it is note 1, read the submissions on the question that only legislature can deal with the subject matter. I'll just, my lord, give some examples. I'm not going to read all 72 categories. Lord, can I, for ready reference, my lord, give the physical copy?
No.
Which page you said, Mr. Solicitor?
Referring to
There's
written
nothing of the kind. In fact, your physical copies, please send them away back to your office.
PDF 113, my lord. I'm sorry, my lord. It was a loose ball. I forgot that I am also using a physical copy, and your lordship's continuing mandamus is being breached. My lord. Kindly pardon me, my lord.
The threat is that they're going to be confiscated.
Yeah, yes, my lord. I will be, my lord, on
There are
12th
these,
October.
Union of
Come to
India
the Union of
submissions.
India
and
submissions कहाँ पर है?
Listening was, this
volume
one.
did you say, solicitor?
Note
Volume?
one.
Note
Note
1.
one. Yes. Got it.
Written submissions, note 1, only the legislature can deal with the subject matter. Is that
That's
what
the
you
title, my lord.
Yes, yes.
Uncover
You're saying
Submissions on the
other
question.
related
one.
definitions, huh? Other related
Union of India
definitions.
folder.
Opening statement.
Union of India folder.
Page,
Yes.
note one.
Page 113 is other
Only
related.
got it.
Note 1.
Just
Only the legislature has the
Paul
power.
is leading us. That's very nice.
Yes.
The PDF number 113?
Yes, PDF 113.
Where all these definitions are given.
Yes. My lord, kindly, my lord, now visualize
DFC.
your lordships were to give recognition to LGBTQ plus, which is an unidentified class of persons, and there are at least 160 statutory provisions in different statutes. How, my lord, we will be able to reconcile with this, my lord, different spectrums and shades? Please see first, agender. A person who does not, your lordship gets, my lord, the Chief Justice,
Yes.
your ladyship gets, my lord. A person who does not identify themselves with or experience any gender. A gender person are also called null gender, genderless, gender void, or gender neutral. Please see 3. I'm just giving, my lord, a flavor, my lord, that it's impossible to reconcile by in a judgment. My lord, even Parliament will have to undertake a humongous exercise if the Parliament, as a policy, decides to recognize the marriage. A gender that is indefinable or indomitable, people identifying with this gender refuse to be categorized in any particular gender identity. So whether they are man or woman, which provision of which law which governs either man or woman, Lord, will be a big question. Then 4, also called ABS gender, this gender identified changes according to one's surroundings. This is kind of a fluid. There is nothing, my lord, specific. Then 6, this is based on the person's mood swings or fluctuations. So a person can be having, my lord, male sexuality for some time and a female sexuality for some time. And say at the time of divorce, if a lordships were to read person and they get the recognition of marriage under the Special Marriage Act, Lord, what would be their gender when we test, my lord, the grounds of divorce?
What is the source of this table, Mr. Solicitor?
Yes.
My lord, this is, my lord, I don't think, my lord, it is. There are various sources, my
Must
lord,
be
but
taken from
essentially
somewhere.
from
Must be taken from somewhere, some glossary or something like that.
medicine net.
Turn to page, the previous page. It gives it the footnote. Courses, medicine. Either.
But my lord, I have checked up from 2-3 sources. This list is consistent.
Yes, yeah.
You've
You have given in your footnote
In the
45.
footnote, yes, my lord, I have given medicinenet.com.
Where is it?
On page 108,
Physical 100.
footnote 45 at the heading. Source, medicine net.
Footnote 43, my lord.
What are
45.
the others? 72
45,
others.
yes. Then, my lords, 8. Alexi gender, the person has a fluid gender identity between more than one type of gender, although they cannot name the genders they feel fluid in. Then, the gender identity stands apart from existing social gender constructs. It means having a strong specific gender identity that is neither male nor female. My lord, transgender, my lord, is different. Transgender, my lord, is conventionally, as we know, is different. Now defined to mean everything, my lord. But transgender means, my lord, the person who has sexual genitals other than what, my lord, he is supposed to be born with. My lord, then amara gender, having a gender identity that changes depending on the person one is emotionally attached to. If a person is emotionally attached to a man, then he has a male sexuality. If woman, then he has a feminine sexuality. Then embonic. The person identifies themselves as both man and woman and yet does not belong to either. Therefore, I repeatedly say this is an unidentifiable class we are dealing with. Then amica gender, a gender fluid identity where a person changes their gender depending on the friends they have. It's also called, my lord, by some as pure gender, my lord. My lord, 18. 17, my lord. Anogender. The gender identity fades in and out in intensity, but always comes back to the same gender feeling. So at particular act, he has one gender identity, then it changes, it comes back. These are not facts I'm giving. I'm without having any value judgment. The only limited purpose of showing is that would it be prudent or possible for the court to lay down, my lord, regulations, even if your lordships are persuaded to confer them with the socio-legal status of marriage. Because then regulating it would be impossible, because there would be 101 contingencies, which, my lord, with best of the assistance on our side, your lordships, my lord, cannot conceive of. Then, my lord, kindly turn the page. My lord, 27, exigender. A gender identity that is between the two extremes of agender and any other type of gender. Both the genders are experienced one at a time without any overlapping. The two genders are described as on the opposite ends of an axis. And bigender, having two gender identities at the same or different times. Then 30, blur gender, also called gender fuss. Blur gender means having more than one gender identities that blur into each other so that no particular type of gender identity is clear. Etc., my lord, etc. I'm not giving examples, my lord. Now, my lord, your lordships are necessarily dealing with an unidentifiable class. Now, please come to, my lord, page 16 of my written submissions. My lord, would it be prudent or legally permissible, my lord, to deal with this subject, my lord, on the judicial side? Your lordships are not examining a prohibition against marriage. My lord, kindly bear this distinction is mine. There is no prohibition amongst LGBTQ plus community to marry. Your lordships are not examining the validity. Your lordships are being requested to confer a legal status of marriage which all religion considers to be an institution. I'm not on the morality of it. Though that would be a valid consideration. Lord, page 4 to 15, I have given, my lord, what is the institution of marriage in the Indian context? In case of Hindus, what the Hindu scriptures say. In case of Muslims, what Holy Quran says. In case of Christians, what Holy Bible says. It's a social institution conferred with the legal status. And all these social institutions are predating the statutes and have accepted marriage as an institution only between heterosexual couples. And again, my lord, we are not sitting in judgment over that decision. That's what the society has accepted since millions of years.
Sulista, where are you referring to on this aspect?
My lord, page 4 to 15
Of
my submissions, my lord. Page 6 to 15, I'm sorry.
Actually,
Even, my lords,
your formulation, you see, is best brought out in page 11.
Yes, my lord.
para 44,
Yes, my lord.
those 4 points.
Lord,
what I-
may I just read, my lord, for your, my lord, so that I make myself more clear. The world religions have shaped the history of marriage and family and continue to form the basis of marriage as an essentially religious concept. While it is correct that there is significant divergence between different faiths and their practices in relation to marriage, what must not be lost sight of is that there is more convergence than conflict in teachings, marriage, and family. All six major world religions overlap on the following attributes of marriage as identity. Then I have given the source. First, each of these religious traditions confirms marriage as a vital and valuable institution and practice that lies at the heart of the family and at the foundation of broader society. Second, each tradition recognizes that marriage has inherent goods that lie beyond the preferences of the couple. One fundamental good of marriage emphasized by Judaism, Christianity, Hinduism, and Confucianism is that the husband and wife complete each other. Indeed, they are transformed through marriage into a new person, a new one, fresh reality. Another fundamental good of marriage is the procreation and nature of children. Lord, this is not an archaic concept. Special Marriage Act uses the word procreation. Children are sacred gifts to a married couple who carry forth not only the family name, lineage, and property, but also the community's religion, culture, and language. All these religions thus see a close relation between marriage and children, just as they saw a close relation, although not an identity, between marriage and sexual expression. And all these religions teach that stable marriages and families are essential to the well being of children. This is what my Lord Kara says in the adoption. 2 years of stable relationship as husband and wife. Third, each tradition regards marriage as a special form of sacrament, promise, oath, or contract over any generic relationship, economic or social. It has a special, unique status, my lord. For Hindus, it is a sacrament. For Muslims, it's a sacred contract, but nonetheless a sacred contract. And across the faith, what is recognized as a marriage is between heterosexual couple. Fourth, each tradition eventually came to insist that marriage dependent in its essence on the mutual consent of the man and the woman. Even if the man and women are represented by parents or guardians during the contract negotiations, their own consent is essential to the validity of their marriage. Jewish, Hindu, Confucian, and Muslim writers came to this insight early in the development of marriage. The Christian tradition reached this insight canonically only in the 12th century, and Buddhism more recently still. Fifth, marriage is a concept that is deeply embedded as a union between two opposite sexes ordained by the religious text and practices, specifically for the furtherance of society and the orderly influence between persons inhabiting the society and following specific religions. Now, your lordships have a variety of shades to be dealt with, variety of problems which are to be encountered, variety of religions and their personal laws, my lord, intermingling. And your lordships have an option on, in my respectful submission, possibly the only constitutionally permissible option, to require the parliament or to wait for the parliament to do that. My lord, please now come to page 16. My lord, I am citing some judgments. I will not read all, but these are, my lord, some very illuminating judgments, my lord. At page 17. My lord, right
1-7.
1-7. It starts at 1-6. The title is Democratic Right of People to Regulate Themselves.
You said,
We as a society has a right to regulate ourselves.
1-7.
okay.
My lord, PDF 25. 21, my lord. PDF is 21, my lord. We as a society, my lord, govern who will be the components of that society, my lord, and that governance comes in, my lord, the elected representatives whom we decide, my lord, to elect. Now, please come, my lord, this Reynold Rajmani, judgment. I'll read only the highlighted part, my lord, so that I don't invest your lordship's more time. It cannot be denied that society is generally interested in maintaining the marriage bond and preserving the matrimonial state with a view to protecting societal stability, the family home, and the proper growth and happiness of children of the marriage. I'll skip the rest, underline portion. But although the grounds for divorce have been liberalized, they nevertheless continue to form an exception to the general principle favoring the continuation of the marital tie. In our opinion, when a legislative provision specifies the grounds on which divorce may be granted, they constitute the only conditions on which the court has jurisdiction to grant divorce. If grounds need to be added to those already specifically set forth in the legislation, that is the business of the legislature and not of the courts. Lord, please, Lord, see these, my Lord, in light of what I'm going to show. The structure of the Special Marriage Act would be, if it is redrafted the way petitioners have prayed for. Even their prayers are, my Lord, absolutely vague. I'll be able to demonstrate that. But first, my Lord, law on the point. 5. When therefore Section 10 of the Indian Divorce Act specifically sets forth the grounds on which a marriage may be dissolved, additional grounds cannot be included by the judicial construction of some other section unless that section plainly intends so at the foot. However, whether a provision for divorce by mutual consent should be included in the Indian Divorce Act is a matter of legislative policy. The courts cannot extend or enlarge legislative policy by adding a provision to the statute which was never enacted there. Lord, therefore, I started by saying that marriage is a socio-legal institution. Its recognition is a matter of legislative policy. Then, my Lord, Keshavanand Bharti, my Lord, kindly allow me to read, my Lord. This would guide, my Lord, us throughout, my Lord, the hearing of this case. How we construe the Constitution in the context of the marriage being given the recognition, my Lord. Underline portion. It cannot be denied that provisions of the Constitution of other countries are designed for the political, social, and economic outlook of the people of those countries for whom they have been framed. The seed of the Constitution is sown in a particular soil, and it is the nature and the quality of the soil and the climatic conditions prevalent there which will ensure its growth and determine the benefits which it confers on its people. We cannot plant the same seed in a different climate and in a different soil and expect the same growth and the same benefit therefrom. Law varies according to the requirements of time and place. Justice thus becomes a relative concept varying from society to society according to the social milieu and economic conditions prevailing therein. The problems which confront those courts in the background of the state of the society, the social and economic setup, the requirements of people with a totally different ethics, philosophy, temperament, and outlook, differentiate them from the problems and outlook which confront the courts in this country. It is not a case of shutting out light where they could profitably enlighten and benefit us. The concern is rather to safeguard against the possibility of being blinded by it. Lord, this takes us to, my Lord, the theory that ultimately societal acceptance is one of the considerations for recognition of any union. And that can be tested only in the legislature. And, my Lord, there is a beautiful passage I'll read, my Lord, from the American Supreme Court, which says that any recognition by the court does more harm to LGBTQ plus community than help them. Because then you are forcing something which should have come from within. That's the logic, my Lord, of the Honorable Supreme Court. Now, my Lord, A.K. Roy, my Lord, 5-judge bench. I'll read, my Lord, the highlighted part. But we cannot transplant in the Indian context and conditions principles which took birth in other soils without a careful examination of their relevance to the interpretation of our constitution. No two constitutions are alike, for it is not mere words that make a constitution. It is the history of the people which lends color and meaning to its constitution. Lord, we cannot forget the historical background and the anthropological background, my Lord, which eventually resulted into creation of an institution called marriage across faiths, across religion. Now, my Lord, your Lordships have seen, but my Lord, Justice Cardozo, my Lord, a little hard-hitting, my Lord, word, but my Lord, it really, my Lord, I would wish, my Lord, to place it. When they say that all we want is a recognition, all we want is the confirmation of our right. The judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is not a knight errant roaming at will in pursuit of his own ideal
process.
of beauty. I'm sorry.
It's the nature of the judicial process.
Process.
you're putting from.
That's correct. That's correct, my Lord. But, my Lord, only few words I wanted to highlight, my Lords. Not the first part, which is slightly, my Lord, a little more harsher, my Lord. But thereafter, he is to draw his inspiration from the consecrated principles, and this is important. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. That's what, my Lord, I am driving at. The class with which, my Lord, your Lordships are dealing is an unidentifiable class. They have their class-specific problems. It would be completely, my Lord, a vague declaration, if at all it is to be made, without, my Lord, conceiving the problems they would be creating, my Lord. The mere declaration would continue. He is to exercise a discretion informed by tradition, methodized by analogy, disciplined by system, and subordinate to the primordial necessity of order in the social life.
Primordial.
I'm sorry, primordial.
I think our own Justice Patanjali Shastri has put it all in that one short paragraph in V.G. Rao. Everything that is on reasonableness and
Yes,
what is the
yes.
role of the court.
Yes. Lord, kindly come to, my Lord, para 74, para 73, 74, and 75. This would be relevant, my Lord, for my purpose, because I'm going to, my Lord, rely upon Obergefell, Windsor, and, my Lord, their dissent. A beautiful dissent, because for us, both, my Lord, majority, minority, both are having persuasive value. It was a thin majority of 5 versus 4. But numerically, yes, majority, my Lord. Dissent is a dissent, but, my Lord, which would really assist your Lordships. Now, your Lordships may kindly see the landmark dissent of Justice Oliver Holmes in Lochner versus New York, which criticized the majority of the court for becoming a super legislature by inventing a liberty of contract theory, thereby enforcing its particular laissez-faire economic philosophy, is still remembered as a remarkable piece of judicial foresight. My Lord, then I have cited, my Lord, this judgment with a reason, my Lord. Please allow me to cite Daybright Lighting. I'll just read, my Lord, the highlighted part.
Yes.
Our recent decisions make plain that we do not sit as a super legislature to weigh the wisdom of legislation, nor to decide whether the policy which it expresses offends the public welfare. Lord, 75, and before I, my Lord, read that, my Lord, I would like to, my Lord, just paraphrase it. Specifically, the dissent of Justice Holmes came to be fully accepted in Ferguson versus Krupa and continues to be the law of America till date. Interestingly, the dissent in both same-sex marriage cases in the American Supreme Court in Obergefell versus Hodge and United States versus Windsor blame the majority for committing the same mistake it did in Lochner suit. I'll read, my lord, and thereafter, what happened after, my lord, this Obserfeld judgment in Dobbs. My lord. This is doubted. Now, your lordships may, my lord, kindly directly come to, my lord. My lord, rest of the judgments are same, that your lordships would not, my lord, as a prudence and as a policy, substitute the wisdom of the legislature. But, my lord, kindly come to page 23, that is, my lord, 27 PDF. Only the highlighted part. Your lordship gets, my lord Justice Narsip. Lord, page 23, PDF 27, my lord Justice Bhatt and Justice Kaul, my lord.
Yes.
Read the highlighted part. The power of the court to legislate is strictly limited. Judges ought to remember that their office is just decree and not just dere to interpret law and not to make law or give law. Chief Justice Chandrachud, my lord, this can be, my lord, said now, my lord, that's my request. Chief Justice Chandrachud can say this, my lord, in the present judgment, my lord, on the lighter side, my lord. Chief Justice Chandrachud, speaking for a constitution bench in Gurbakh Singh, CBA versus State of Punjab, has clearly pointed out the limited powers of the court to make laws in construing the provisions of the statutes. The learned Chief Justice has observed the true question is whether by a process of construction, the amplitude of judicial discretion which is given to the High Court and the Court of Session to impose such conditions as they may think fit while granting anticipatory bail should be cut down by reading into the statute conditions which are not to be found therein. Our answer clearly and emphatically is in the negative. Nothing more can be read into the statute. Then, my lord, again the learned Chief Justice warned, judges have to decide cases as they come before them, mindful of the need to keep passions and prejudices out of their decisions. And it will be strange if, by employing judicial artifices and techniques, we cut down the discretion so wisely conferred upon the courts by devising a formula which will confine the power to grant anticipatory bail within a straitjacket. Therefore, even if we were to frame a code for granting of anticipatory bail, which really is the business of the legislature, it can at best furnish broad guidelines and cannot compel blind adherence. The court, by its very nature, are most ill-suited to undertake the task of legislating. There is no machinery for the court to ascertain the conditions of the people and their requirements and to make laws that would be most appropriate. Further, two judges may think that a particular law would be desirable to meet the requirements, whereas another two judges may most profoundly differ from the conclusions arrived at by two judges. Conscious of these handicaps, the law requires that even an amendment of the Supreme Court rules, which govern the procedure to be adopted by it for regulating its work, can only be effected by the whole court sitting and deciding. Lord, the court puts a word of caution that though, my lord, one of the finest, my lord, intellectual brains of the country would be deciding this, but that would not reflect the will of the people. Then, your lordships, my lord, kindly come to page, my lord, I'll just read, my lord, at page 24, that is 29 foot. My lord, it's a constitution bench judgment and only the highlighted part at page 29, my lord. 25, my lord, PDF 29. The court also needs to be mindful that a legislation does not become unconstitutional merely because there is another view or because another method may be considered to be as good or even more effective. like any issue of social or economic policy. It is well settled that the courts do not substitute their views on what the policy is. But my respectful submission is policy throughout all legislations, including Special Marriage Act and Hindu Marriage Act, is recognition of marriage as a socio-legal institution between heterosexual couples. That policy can be reviewed, reconsidered, and redecided by the Parliament, having, my lord, after having wider consultations and, my lord, after gathering all the facts, gathering all possible scenarios which need, my lord, to be regulated. Now, your lordships, my lord, come to page 26, my lord. 20, that is 30, PDF 30. First unnumbered paragraph, my lords. As my Lord Justice Bhatt and Justice Kaul has done.
Dobbs.
Yes. May I read, my lord, with my lord's permission?
Yes.
Your lordship gets one. My lord, the Chief Justice gets one.
Page 30, right?
Yes, PDF 30, my lord.
Yeah.
First unnumbered paragraph.
Yes.
This understanding has also come to be judicially accepted even in the United States, which had earlier permitted same-sex marriage by judicial decision. The United States Supreme Court in Dobbs versus Jackson Women's Health Organization has held that fundamental rights must be objectively, deeply rooted in the nation's history and tradition. Justice Clarence Thomas, in his concurrence in Dobbs, noted specifically that this meant that the court should reconsider Obergefell versus Hodge, which 5-4 permitted same-sex marriage by a judicial verdict, in which the Supreme Court by a judicial order granted recognition to same-sex marriage. Further, the majority led by Justice Alito in Dobbs' case was emphatic in what it referred to as usurpation of power by the court and held that the issue be returned to the elected representatives after doubting Obergefell, which permitted same-sex marriage. And in Dobbs, they say, we send it back to the elected representative, namely the Senate. Lord, please read, my Lord, Justice Alito. Roe, my Lord, that is Roe versus Wade, my Lord, your lordships are aware. Roe was on collision course with the Constitution from the day it was decided. Casey perpetuated its errors, and those errors do not concern some arcane corner of law of little importance to the American people. Rather, wielding nothing but raw judicial power, the court usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. Casey described itself as calling both sides of the national controversy to resolve their debate, but in doing so, Casey necessarily declared a winning side. Then again, my Lord highlighted the underlined part. Put aside the second and third factors, which were based on the court's flawed account of history, and what remains are precisely the sort of considerations that legislative bodies often take into account when they draw lines that accommodate competing interests. The scheme Roe produced looked like legislation, and the court provided the sort of explanation that might be expected from a legislative body. Lord, reasons which the petitioners urge are the reasons which can be given, accepted, rejected by the Parliament. Our decision returns the issue of abortion to those legislative bodies, and it allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office. Neither decision has ended debate over the issue of a constitutional right to obtain an abortion. Indeed, this case, 26 states expressly ask us to overrule Roe and Casey and to return the issue of abortion to the people and their elected representatives. The states were before the court. So out of 51, 26 said that you overrule this. Return it to us. It's our domain. This court's inability to end debate on the issue should not have been surprising. This court cannot bring about the permanent resolution of a rancorous national controversy simply by dictating a settlement and telling the people to move on. Whatever influence the court may have on public attitudes must stem from the strength of our opinions, not an attempt to exercise raw judicial power. We do not pretend to know how our political system or society will respond to today's decision overruling Raw and Kese. And even if we could foresee what will happen, we would have no authority to let the knowledge influence our decision. We can only do our job, which is to interpret the law, apply long-standing principles of stare decisis, and decide this case accordingly. We therefore hold that Constitution does not confer a right of abortion. Raw and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. We end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Raw and Casey arrogated that authority. We now overrule those decisions and return that authority to the people and their elected representatives. Now, my Lord,
Mr. Solicitor,
yes, ma'am.
these judgments which you have cited on the limits of judicial power, that principle of law is well settled. I mean, there's no question about it, that judges don't legislate. The power to frame law, to look at the myriad different social complexities, is entrusted to the legislature, whether at the center or in the states.
Yes, ma'am.
That principle is a well settled principle. But if you are relying on Dobbs to support that principle, then we have gone far beyond Dobbs in India.
I know, my Lord. I know. I'm going to cite your Lordship. Yes.
Dobbs represents a view of the American Supreme Court that a woman has no bodily control over her own bodily integrity.
I'm not.
This theory has been debunked long back in our country.
Correct, my Lord.
So therefore, I mean, you are citing the wrong judgment. You are citing the wrong judgments in support of the principle.
Lord, the principle is that the issues concerning moral or social implications be returned to Parliament. That's the limited point.
Fair enough. But don't cite Dobbs, because we have gone far beyond Dobbs here. And fortunately so.
Lord, Dobbs have cited.
I think we can at least credit ourselves that, we are far ahead of our times than many of the Western countries in that.
Lord, I am never a fan of, my Lord, citing foreign judgments. My Lord,
certainly not Dobbs.
No, my Lord, I would say none. But, my Lord, not Dobbs. I understand. My Lord, Dobbs, we may have an issue, my Lord, even I have a personal issue with the subject matter it dealt with. We are not concerned, my Lord, with the subject matter Dobbs dealt with. Abortion is a right of autonomy of a woman. I'm not on that question at all. I'm on the principle which it laid down.
For instance, our law granted only to a married woman the right to obtain an abortion between 20 and 24 weeks. We dealt with that restriction. When an unmarried woman came before us and said, well, I must assert an equal right to an abortion. And we upheld that right, saying,
my Lord, I'm at the cost of repetition.
We have gone far beyond. I mean, much of the recent jurisprudence, on Dobbs and the overruling of Roe versus
I am at the cost of repetition.
Said on this jurisprudence, actually.
Lord, at the cost of repetition, I say, Dobbs is not relied upon for what it decides on the facts of that case. That we have proceeded much further, and we have always been much ahead of America or any Western countries in every which way. Unnecessarily, we follow the
principle that on complex social and moral issues.
That's the only limited ratio which I am relying upon.
Definitely, legislature, that point is well taken, but not.
Yes, that's the limited point. My Lord, I am not supporting, my Lord, the judgment on abortion rights, my Lord. Obviously, your Lordship knows, my Lord, everyone has a problem with that. But question is, when it concerns a debate, when it concerns social implications, return it to the people's representative. That is one reason. Second reason, my Lord, this Obersfeld is doubted here, which petitioners have relied upon. Lord, that is one reason. My Lord, forget the abortion part of it. I am not supporting that judgment, but I am nobody to support or oppose that judgment. I am citing it only for this limited purpose of showing that this is an issue which must be first reflected, debated, discussed, and, my lord, decided by the Parliament. That's the limited purpose. But please see, my lord, Justice Clarence Thomas, my lord, my lord, only highlighted part, only underlined portion. Forget, my lord, the this abortion part. I'm not on that, my lord. I also, my lord, do not agree. Your lordship's judgment in, my lord, termination of pregnancy takes care of it. I'm not on abortion at all. My lord. That's fact specific. But while dealing with some facts, when your lordship lays down the ratio, I cite it. This is
Fair-
the ratio.
Fair enough.
My lord, please see, my lord, only highlighted part. My lord, Obersfeld versus Hodge. My lord, your lordship gets, my lord?
Yes.
My lord, concurring view of Justice Clarence Thomas. For that reason, in future cases, we should reconsider all of this court's substantive due process precedents, including, then, my lord, de inter alia. My lord, I'm not reading all, but, my lord, even this Obergefell.
But going by this logic, we would be reconsidering the entire line of our precedent from Manekar to Shaira, which is not your submission also.
It's not my submission. It's not my submission. But my submission is, my lord, the last part of Justice Alito.
Yes.
Social implication, return it to the Parliament. That's it. My lord, now, my lord, I have given the table. My lord, I'll read, my lord, those judgments a little later. But please come to page 29. I'm sorry.
Go ahead.
Yes.
I'm sorry, if I... Lord, page 29. Lord, I have compiled for your lordship's assistance, Lord, two things. The
Yeah.
countries where same-sex marriage is permitted.
Yes.
And I have bifurcated them that except with the 2 or 3 exceptions that came from legislature and not by the judicial pronouncements.
Right.
Number 1. Number 2. Lord, as I have pointed out, this is, Lord, something crucial. Lord, when your lordships recognize something or the legislature recognizes something, it will have impact on other laws, which I will demonstrate. Wherever the legislature has stepped in whichever country's jurisprudence, they have correspondingly amended other statutes, which only Parliament can do. None of the other statutes are in question before your lordships. So the suggestion of the petitioner that keep the threads hanging, that is not permissible. My lord, that is taken care of by various statutory amendments by various.
Let's have a quick glance at these.
Well, kindly have,
Post
Lord.
legislation.
Endora, my lord, by legislature. Then, my lord, I'll just, it's a, my lord, translation. It was originally, my lord, we got it translated. It's a Google translation. I must, my lord, at the outset put a caveat, my lord. There may be, generally, it's not, my lord, much of discrepancy, but maybe some lacking in accuracy. Marriage contracted in civil form has the same requirements and effects, whether both contracting parties are people of the same or different sex.
So
This is
listen,
what, my lord, the new statutory regime brought by the legislature says. But what is important is, legislature made following consequential changes. The Amendment Act of February 2023 amending the following provisions: Article 77 of the Family Code on forms of marriage, 78 of the Family Code on effects of civil and canon marriage, Article 91 on civil consequences of entering into a canon marriage, and Article 244 on the competence of Andorran authorities to celebrate civil marriage. Maybe some local requirements there. But the point is that whenever legislature does it, my lord, it applies its minds and makes corresponding changes. Lord, then Argentina, by legislature. Translation: marriage will have the same requirements and effects regardless of whether the I'm sorry, my lord.
Yeah.
My lord, possibly, my lord, Justice call is on mute, my lord, if your lordships are asking me something.
No. I am right there where you're reading it.
Oh, I'm so sorry. I thought my lords are putting some
I
questions.
was putting a question. I was trying to put a question.
Yeah, I'm so sorry, my lord.
Rather a suggestion. Instead of reading the whole lot, I think this is a chart which segregates, say, puts a classification.
Correct.
And out of the 34, there are 34 countries. Of that, 29 countries have straight away legislated.
All of them.
And even the legislatures are done in a graded manner.
Correct.
And in 9 other cases, these legislations have been preceded by some court directions or decisions.
Reverse, my lord, it's converse. If your lordship comes at page 42, that is 46, my lord, PDF 46, I have given. My lords may, my lord, come to page PDF 46. Your ladyship may see, my lord, I have given.
Legislation is the legislative process 24. Countries where the recognition was through a mixed process initiated by the legislature.
Initiated largely by legislature or executive.
But
Then,
there-
my lord, it
South Africa is one
the court
exception.
stepped in.
South Africa is the exception in that sense.
Yeah, yes. my lord.
But then I think you have also to take into account Taiwan and Austria.
Yeah, I know, my lord, but kindly turn the page over.
Yes.
I'm sorry, my lord. Taiwan, please see, my lord, page 41. My lord, that is 45 PDF.
Yes.
I'm going to, my lord, read, my lord, Taiwan Supreme Court also, my lord, where the dissent also will be illuminating, my lord, to your lordship. So, my lord, mixed process. Taiwan, your lordships have, my lord?
Yes.
My lord, Justice Butt and Justice Call has, my lord?
Number
Yes.
31.
Number 31, yes, ma'am, number 31. Mixed process. From 2015 to 2017, several municipalities, local governments of Taiwan, like so-and-so, 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 allowed registration for same-sex marriages and allowed civil union of sorts. In 2017, the Ministry of Interior formally asked all local governments to open registration for same-sex couples. It was after the said legislative or executive process that in Judicial Yuan Interpretation number 748, the Constitutional Court further expanded rights to allow formation of permanent unions to include same-sex couples. It started initially by legislature, then executive stepped in, and then the judgment, my lord, of
Now you have the law, I think, in 2019.
yes, my lord.
And even in Austria, now let's see, because Austria is one case which was given, which is shown to us.
My lord, page 34, your lordship would get. My lord, the chief justice, 34 PDF. 34 is Austria.
Yes. Now, what is the position? Even there, it was
Yes.
followed by legislation.
Yes, my lord, legislature provided for registered partnership for same-sex couples in 2010. The relevant provision in section 3, my lord, translation, a registered partnership can only be founded by two people, registered partners. In this way, they form a long-term partnership with mutual rights and obligations. Role of court. In January 2013, the Constitutional Court ruled that the registered partnership law was partially unconstitutional, broadening the rights of registered partners. On 4th December 17, the Constitutional Court struck down the ban as unconstitutional, ruling that preventing same-sex couple from marrying violates the principle of equality and non-discrimination. Lord, there was a prohibition which came to be challenged. Lord, therefore, my lord, I started by
As
saying,
in the case of Windsor.
Yes.
As in Windsor also
Yes,
the prohibition
yes,
was
yes.
challenged.
because there is, your lordships are not, my lord, confronted with a situation where there is a law prohibiting same-sex couple, my lord, marriage.
The UK was a situation where they first recognized by a law civil partnerships in 2006.
I think
And
that
thereafter, 7 years
2004.
later, they enacted the
2004.
Marriage Act.
Yes.
the UK is very interesting. You might read
Yeah.
that.
You just see the UK actually, your page item 32
Yes, my lord.
at PDF 45.
Yes, ma'am. I'll just.
But
United Kingdom.
remember, Gaidan was 1999 or
My
2000.
lord, Gaidan, my lord, was, my lord, cited out of context, my lord, and I have, my lord, given a detailed note on Gaidan in this.
Mr. Solicitor, just keep parcels to this, because Gaidan was in some other context, one realizes. That was in the context of a tenancy where
Then, my lord, the one, my lord, Rent Act was in question. That apart, even there is another, my lord, fundamental, foundational distinction, which, my lord, I'll come to, my lord. But please see item 32 by legislature.
And that's
Civil Partnership Act 2004 came into effect in December 2005.
Actually, in the context of of a tenancy, the real principle is of settled residence. So the law gave protection to the surviving spouse of an erstwhile tenant. Why is that protection given? We also have it in our Gyan Devi Anand, that whole line of cases from the Constitution bench. The idea is that when a tenant dies, anybody who's in settled residence as a member of the family should also be entitled to the protection of tenancy, which is otherwise a heritable asset. That's the principle.
Correct. My lord,
Gaidan
may I
also
come to
said,
Gaidan
Gaidan also said the
separately,
same
my
thing,
lord.
that, well, if you have a same-sex couple, even though, the statute doesn't recognize a same-sex surviving spouse, the principle they adopted was, the principle is really that of a settled residence. And the idea is to protect, as a matter of social welfare, one of the occupants of that particular tenancy, then that should not be deprived to a same-sex surviving spouse.
Yes,
That
your
is-
lordships are right.
Yeah.
That was the fact. But my lord, forgetting the fact, the principle which was relied upon was fundamentally flawed, my lord, and that's my separate argument. Why, my lord, Gaidan would not apply in the Indian context.
Just read now 32 at internal page 45.
32, my lord, I was at 32. United Kingdom, the Civil Partnership Act 2004 came into effect in December 2005. It created civil partnerships which gave same-sex couples who entered into them most of the rights and responsibilities of marriage. Thereafter, the Marriage Act 2013 for
This is-
England and Wales.
Mr. Solicitor, this act, you described it in a very classical form, but actually that resulted in amendment to a lot of other enactments in 2004 itself.
Yes, my lord, your lordships would find that at PDF 549. My lord, volume 5 of our compilation, PDF page 549. 2013 Act, my lords, we have placed them on record. Place that act on record. That is marriage within bracket same-sex couples bracket over Act 2013.
So that resulted in an amendment to various other enactments.
And
That
then
is
two-
also,
and
my
then
lord-
2013 led to a series of amendments thereafter.
Correct, my lord. That is also, my lord, part of that, my lord. I'll come to that, my lord, after showing this. Because right now this chart was only for the limited purpose of showing that it initiated by the legislature, except in case of, as my lords have rightly said, my lord, Taiwan and Taiwan also not fully, but South Africa. And South Africa I have mentioned, my lord, at page 43, my lord, that is 47, PDF 47. Now, your lordships gets, my lord, at the top, my lord, the Chief Justice gets, my lord.
Yes.
Possibly the only country subject to verification, but we tried our best to verify. South Africa is the only country where the process was first initiated by judiciary
Which
and
is
then
Puri,
followed by.
which is Puri's case. Puri, which
Yes.
was read out by Mr. Grover.
Yes, my lord. Then, my lord, countries where civil unions are legal. That also, my lord, we have given. But I'm not going one by one.
No, we'll just only look at the headings of the.
Yeah,
And if we
that's
come
right.
across, any one of us comes
There are
across
some-
something interesting, we can pause
There are
there.
some mixed processes.
Yeah, my lord,
Indicate.
for example, Bolivia is by judiciary.
Brazil,
Because, my lord,
yeah.
Second Constitutional Chamber of La Paz Department Court of Justice, citing advisory opinion number so-and-so, issued by the Inter-American Court of Human Rights, ruled in favor of the couple recognizing same-sex civil union. However, it may be noted that several bills had been introduced in the country's legislature seeking recognition, and the political debate was ongoing on the said issue.
Look at Latvia. Something very interesting happens in Latvia at item 9.
Yes, my lord. By judiciary first, thereafter legislature. Latvia does not recognize same-sex marriage, but same-sex couples are able to register their partnerships with the government through the courts. On 12th November 2020, the Constitutional Court of Latvia ruled that the Latvian constitution entitles same-sex couples to receive the benefits and protections afforded by Latvian law to married opposite-sex couples and gave so-and-so until 1st June 22 to enact a law protecting same-sex couples. That may be as per their constitution. Your lordships never issue writ to parliament.
A lot of countries, of course, we don't follow that model, Mr. Solicitor. I mean, we are now discussing at a theoretical level. Some countries have followed this doctrine where the judiciary say we give you 3 months to take steps to enact law, for instance, so 3 years or 1 year or whatever. If you don't, then this will follow. So Latvia seems to have followed that.
That, my lord. But that, my lord.
No, I began by saying that we have not, we scrupulously say no mandate.
Your lordship have always, my lord,
to parliament.
Scrupulously, my lord, never issued.
There are countries which follow that, yes. We declare the law, we give you so much time, put the law in order.
Depends upon the constitution. Like, my lord, in Great Britain, the parliament is completely sovereign. My lord, there is no power to declare the law unconstitutional, etc. My lord, that depends upon the constitutional culture, as I say, my lord. But our, my lord, constitutional position has been consistent, my lord.
Let's scroll down.
Then, my lord, summary is at page 49 PDF. Civil union position. Then countries where civil union or a partnership arrangement is given recognition, 16. Countries where recognition was through purely legislative process, 13. And country where process was mixed, 3. Number 98. Therefore, it is clear that societies and countries have acted only after the said concept has gained currency or acceptability in their respective jurisdictions, and the elected representatives have acted on the basis of locally prevailing ethos, beliefs, and understanding of marriage or civil unions. It is submitted that therefore there was a clear and direct democratic mandate behind the recognition of same-sex marriages in which ever jurisdiction such relationship were recognized.
Sir, Mr. Solicitor, if you don't mind, can we now just skip a little bit and go to page 54? Let's now go to the heart of the matter, which is the legislative intention behind this, because you've given us a flavor now.
Yes,
substantially gone through your...
Did your lordships, my lord, consider coming to page 50 instead?
Those judgments which say about legislative policy and other things,
Yes,
those you've given them to us, and it's very well basic doctrine. I don't think we need to read it together. Prim grana
and the proposition is,
and everything, yes.
Some of them are constitution bench judgments. That's all I wanted to highlight. And my lord, the purpose, as I pointed out yesterday, was that I'll quote the paras rather than burdening the volumes, so that your lordships can immediately.
Brother Call and Brother Bhatt are not here. I don't online. They're online. I think those judgments at page 50 to 54, we need not spend time going through them, right? It's basic doctrine, so they're well known. So we can just maybe look at them and go to the real
legislative intention behind Special Marriage Act.
I think yes, exactly. We'll go straight to page 54. I think.
Your lordships, sorry, page PDF page 54. Well, the purpose
is say that those judgments are not relevant, but there's just they're so basic that I don't think we need to spend time reading through them. That's why.
There are settled positions your lordships are fully aware of. This is just, my lord,
let's
so that
see now how you've formulated at page 54 PDF.
Yeah, my lord, 54, my lord, I'll just put, my lord, 2 propositions. Why, my lord, I'm going through the debates. It might at some time, my lord, appear to be a little irrelevant, but please go through it. My lord, this is the debate when Special Marriage Act 1954 came to be enacted for 2 purposes. A, the intention was heterosexual, intra-faith, but heterosexual.
Just 1 second.
I'm sorry, interfaith, not interfaith, intercaste, but heterosexual.
Religious and irreligious, or no religious?
Yeah, yes.
It's only distinction between
actually it was religion neutral.
Correct.
The SMA was intended to be religion neutral.
Yes. I would, my lord, nothing turns on that, but just academically, my lord.
Idea was because to create a platform where couples were not going to marry within the fold of their personal law.
the faith.
In that sense, religion
I'll
neutral.
just, my lord, just academically, nothing, my lord, may perhaps turn on this. Uh, Even if I accept that it's a secular law or a non-religious law, my lord, it has taken some concepts of uncodified Hindu law. For
Of course,
example,
it does prohibited relationship.
degrees of prohibited relationship. That is Sagotra and Sapinda relationship.
Absolutely.
But in the format of, my lord, a religious or a non-religious statute. Some concepts, my lord, are there. Prohibit degrees
The
of
whole object was to permit two couples, two individuals who profess different faiths to have a
two different
allow-
individuals of opposite sex.
That's what we are now considering. But the idea was basically it was to allow two people who did not profess the same religion to have.
Or maybe the same religion, but different castes.
Correct.
Correct, you are right.
Because section 21A, my lord,
That's why Arundhati referred to the caste disability
Yes,
Act and other things.
Dr. Ambedkar piloted this bill, and this is before
the reason was, my lord, your lordships have been shown, my lord, by Ms. Kaju. Lord, it was earlier 1872 law, where if I marry under that special marriage act, I have to denounce my religion. So therefore, my lord, that was brought back by 21A.
21.
Mr. Solicitor, you'll not be completing tomorrow, today. So tomorrow when you resume, maybe if one of your juniors can do a little exercise taking from the table which Ms. Kaju has prepared.
Yes, yes.
And give us a 2-page note or 3-page note on the antecedents of the SMA.
Yes, yes.
Just take, you'll get the material from that note and just sort of develop it into a 2 or 3-page note for us tomorrow morning.
To some extent, my lord, I've set out some of the materials of the debates and so
Right.
on in the additional compilation which I had filed.
Do we have the statement of objects and
Yes,
reasons?
we do. So which refers again to.
No, debates also mentions that. My lord, there is
All right,
a
let's
flavor
see that page
in the debate.
54.
Now, the
Page-
second point, my lord, your lordships may bear in mind. My lord, it was argued that in 1954 there was no concept of gays, etc. And therefore, obviously, there was no mention. Your lordships, my lord, that was Mr. Rodgi's submission. My lord, my respectful submission, my lord, and I'll take your lordship to that, are twofold. A, even if that is so, that is no ground for the court to rewrite and include something not intended. B, they were aware of it. There is a discussion on that. And therefore, I'm going to respectfully submit that there is a conscious omission. That's one more reason why it cannot be read into. Lord, may I read, my lord? This, my lord, I may read a little, my lord.
Yes, that's
slowly.
right.
105. At the outset, it may be noted that if the principle canvassed by the
Just one
petition,
second.
1 minute, 1 minute.
Is that page-
I'm sorry.
Page 50.
it is
Page
54
Same
PDF.
volume.
54. Okay.
Yes.
Lord, its title is Redrafting Exercise of Special Marriage Act, your lordship gets. My lord,
Yes.
Justice Narasimha gets. Yes. At the outset, it may be noted that if the principle canvassed by the petitioners, that word man or woman or other phrases representing the two opposite sexes are capable to interpretation in a gender-neutral manner, it would open up a whole host of statutes and provisions to constitutional susceptibility. My lord, your lordship can skip that. 106. As far as the present case is concerned, the debates in Parliament during the framing of the Special Marriage Act and the Hindu Marriage Act 1956 are illustrative in this regard. The said debates clearly identify that the entire architecture of the statutes was premised on opposite sex marriages and the provisions surrounding the legal recognition of marriage, the succession amongst children, and other aspects as are all completely premised on the legislative presumption of opposite sex marriages. The Parliament was aware of gays and lesbians even in 1954. However, it is clear that the Parliament took a conscious call of not mentioning them. It is interesting to note that the Select Committee on the Special Marriage Bill 1952 approved Section 4 of the bill in a form which did not use the word male or female and rather use the word parties. The clause is quoted as under, my lord, as per Select Committee. The parties have completed the age of 18 years. Each party, if he or she has not completed the age of 21 years, has obtained the consent of his or her guardian to the marriage. This is substantially what they want, my lord, to reinterpret. It was after a heated debate going on for days and days that Pandit Thakur Das Bhargav brought an amendment that provided for separate ages for boys and girls in the form of 18 years and 21 years. It should be reverse. Boys and girls respectively 21 years and 18 years. It is submitted that apart from the above, the debates clearly show the limited purpose behind the enactment and the clear, unequivocal understanding of marriage as an institution between opposite sexes. The speech of learned Minister of Law and Justice at the time, Sri Charan Chandra Biswas, is illustrative in this regard. The relevant portion of the debates are as under. Then Sri Biswas. Let me now refer specifically to some of the salient features of the bill. The first is, as I have already pointed out, marriage under this law will not require the parties to forswear their religion or to declare that they do not belong to any religion. Any two persons residing in India will be eligible to marry under the provisions of this law. It is permissive, no doubt, but it is compulsory only to this extent that if they marry under this law, the conditions herein laid down must apply. They must make up their minds as to whether they wish to be subjected to these conditions. If they do not choose to be subjected to these conditions, it is open to them to discard this and to marry according to the law which now governs them. That was, my lord, personal uncodified law, which does not prohibit LGBTQ plus marriages. Yes, except, my lord, in case of LGBT. Yes, my lord, Hindu Marriage Act prohibits. Yeah, my learned friend is right. My lord. The Act of 1872 applies to two categories of persons. Firstly, to persons who do not profess any of the major religions of the country, and secondly, to persons who profess the Hindu, Buddhist, Sikh, or Jain religions. The result is that this act does not permit any interreligious marriages unless the parties are prepared to forswear their religions. If they are Hindus, then both of them must be Hindus. If they are Buddhist, both of them must be Buddhist. If they are Sikhs, both of them must be Sikhs. And if they are Jains, both of them must be Jains, in order that they may marry under the Act of 1872 as it stands now. For the first time now, we are going to do away with all distinctions based on religion. The bill, if passed, will permit of interreligious marriages. Religious differences are put out of the way altogether. Government feel that the time has now come when religious differences should not stand in the way of a couple getting together. If they feel that their lives are cast together and the fact of their marriage should not in any way affect their religious belief, that is the main change. This is the legislative intent, my lord. Now, Mr. Sri Biswas, my lord, the underlined portion. Under the provisions of the original, I may read, I'll read the underlined portion. Under the provisions of the original act, none of the parties to the marriage could belong to any of the recognized forms of religion mentioned therein. Now, two persons, if they belong to the same religion, will be allowed to marry. But this privilege is confined only to Hindus, Buddhists, Sikhs, and Jains. That is because the main rights which were secured by this act were monogamy and divorce. The religions which were excluded already provided for monogamy and divorce. The Christian Marriage Act is monogamous and divorce is permitted. Muslims also have the right of divorce, though it is not monogamous. Kindly, my lord, turn to the next page. Lord, nothing may turn, my lord, on other debate. Srimati Reena Chakravarti, Mr. Deputy Speaker, sir, I do not propose to answer various things that have been said just now because I feel it is very difficult to answer people whose mind still remains in medieval times. It is even more difficult to convince anybody who thinks that he himself has the monopoly of all morality and everybody else who demands progress immediately seems to be having some problem with someone, as we can read between the lines. Himself was the monopoly of all morality and everybody else who demands progress immediately should be dubbed as irreligious. We support this bill because the principles underlying this bill is progress. The entire idea is to have contractual form of marriage without the necessity of repudiating religion, which was necessary in the Bill of 1872. This is the spirit, this is the heart and soul of the Special Marriage Act. My lord, next, my lord, speech by Sri Biswas, the Honorable Law Minister, is just to show that it was not a Brahmo Samaj oriented or Brahmo Samaj inspired piece of enactment. The Honorable Minister says that Brahmo Samaj, of course, is one of the major my lord, contributing factors, but not the sole contributing factor. Now, kindly come to my lord 57. PDF 57, my lord. My lord, at the third unnumbered paragraph, Sri Biswas. I was just going to read from the Act of 1872. It's, my lord, it can be avoided. My lordships may come to
58.
at the foot on homosexuality. Your lordship gets, my lord?
Yes.
At the foot, my lord, there is a title. This is debate dated 6th of September 1954. See, Raghava Hari, Penukonda. I do not wish to take up much time from the arguments that have been advanced for straying away from a thing that has been recommended by the other house. I am not satisfied that there has been a fair or a clear approach to the matter, but only there is an attempt to confuse the issue. One thing that I find is that this act was meant to afford an opportunity for advanced people, people with reformed ideas and people who are economically independent and have their own judgment, mature judgment about their course of action for the future. It is only for such people that this Special Marriage Act was intended. In the course of their arguments, members have been urging that the marriage age in the country should not be high. That is too old an age, and that therefore more people cannot come under this act. 21 and 18 was considered to be too old, my lord, in those days. It was also stated that this was only a permissive legislation to people who want to take advantage of it if they are in position to understand what they are about. You will see that the whole thing, you will see that the whole thing is made topsy-turvy. The idea was that the people who have attained a certain age, when they can make up their minds, nobody should interfere with their judgment. Now you want to reduce the age and put in a guardian. Why this spoke in the wheel? You know that this is permissive legislation, that marriage can be permitted between a person of one sex with any other person who is of other sex. This is what they understood, my lord, throughout. That is the heart and soul running, my lord, through the debate, irrespective of caste, community, religion, anything. Then you want to introduce the element of a guardian's consent. Do you expect that the guardians are more advanced than the present generation, which want to marry without the guardian's consent? I am afraid this guardian's consent for marriage between people, which you are introducing, is going to be the cause of all that ineffectiveness of the legislation. Then Dr. Jayasuriya, I beg to move in page 9, line 43, after sodomy, insert with her homosexuality. But sodomy was a ground for divorce. He said, insert this also because this is prevailing. It would come. That this is now quite prevalent. Mr. Iyengar, notwithstanding the fact that prohibited degrees have been brought down, I do not know whether the next generation may not say that a brother can marry a sister. According to Mandal's law, the idiosyncrasies of parents among animals will persist or generations. My friend Dr. Jayasuriya will support me in this. Is this law to be ignored in case of men? A man must marry only a woman. He cannot marry a man. Is this all that counts? Then, my lord, on marriage between opposite sexes, Mr. Achyutan, I agree with that viewpoint. The girl and the boy must have sufficient maturity, sufficient age growth to understand the consequences by which they will be tied when they marry under the special law. So there is no necessity, no special ground, no coherent ground for saying that it must be reduced to 18. Moreover, according to me, why marriage means early responsibilities. There might be a sexual feeling, patience which will be there and all that. We must try to restrain them. According to me, youngsters cannot think of marriage before 25 or 22. It is not simple matter. It is a serious thing, so that the age limit must be at least 21. There cannot be any reduction either in case of the boy or in case of a girl. Again, my lord, they were talking of opposite sexes. And Mr. Deputy Speaker, my lord, Mr. Chaudhary. Your lordships may, my lord, kindly come to, my lord, the bottom. My lord, kindly, no, my lord, just third para, my lord, from the top.
The floor of the house can't really.
At that time, solicitor,
Yes, my lord.
were there laws permitting same-sex marriages anywhere else in the world? I think
Not to our knowledge, my lord. There was no prohibition, but not to.
even in England there was a prohibition. Till 73, I think it was prohibited. So there perhaps was no platform, no legal foundation for a marriage or a marriage like you recognized by law when this was all debated.
Your lordships are right, my lord. Possibly in India also, my lord, till 56, when it became man and woman, bride and bridegroom, but there was neither permissive nor prohibitive. That Shastric law, my lord, that uncodified Hindu law would apply, my lord, that may have, my lord, repercussion. My lord, page 59, PDF 59, the third from the bottom, Srimati Amu Swaminathan. Your lordship gets that, my lord. I rise to support the amendment moved by Pandit Thakur Das Bhargav, which provides that the man has completed the age of 21 years and the woman the age of 18 years. Now, my lord, what my learned friends want us to read is a person has completed the age of 21 years and a person has completed the age of 18 years. We do not know, my lord, which person, who is man, who is woman. We do not know. Unless we destroy the structure and fabric, my lord, it would not be possible to read the way, my lord, the petitioner want. Srimati Da Pala Chaudhary. I shall be still briefer than the one who have gone before me. I fully support the amendment of Pandit Thakur Das Bhargava because it is quite right that girls of 18 and boys of 21 should be allowed to marry. Then Pandit K.C. Sharma. I am rather surprised at the arguments of my friends both supporting this bill as well as opposing it. It is simple measure. In this country, in the Hindu, Christian and Mohammedan religions, marriage is predominantly governed by personal law and these are rules of conduct for the husband and wife in all these religions. Then cases had happened when marriages were to be performed and the people did not belong to these religions. So in 1872, a law was passed, the Special Marriage Act, under which certain people who did not belong to certain religions could perform their marriages, and the basis of the marriage was contractual. That is, as human beings, the young man taking the young woman as wife and the young woman taking the young man as husband. When they took each other as husband and wife, it did not follow that they said goodbye, as Mr. Nandlal Sharma said, to everything decent in human life. That is not the question. The words husband and wife are significant words. There are certain implications, a certain significance, a certain meaning behind them. And the young man and the young girl who took each other as husband and wife undertook to observe the law of decency and good conduct in the society. It cannot be said that because they married beyond the Hindu, Muslim, Christian, or any other religion, therefore they said goodbye to everything that was good in those religions. That is not the point. For my friends' information, I may say that even in the Rig Veda it is stated that you, the young girl, go to the youngest man, be thou mother of heroic children for the good of the society. The good of the society means the good of the race. Therefore, the emphasis is not on the performance of yajna as such. The emphasis is on looping the thread of the race alive. What is important is the progeny. Therefore, the emphasis lies with regard to the race, not with regard to the religion. The contractual form, I may again mention, is not doing away with everything ethical or decent in life. The simple difference was the sacramental forms were done away with. That a Hindu was not required to go 7 times round the sacred fire. But it does not follow that because he has not gone round the sacred fire 7 times, therefore everything that was said before the sacred fire was not in the mind of the girl or boy. They say, we observe, my lord, so and so, and last line, under the proposed bill, any Indian citizen can marry another Indian citizen, of course, of the other sex. Now, your lordships would find this debate was simultaneously going on with regard to Hindu Marriage Act also. It was, my lord, a composite, comprehensive, my lord, exercise which was being done. And having the similar provision on sodomy. My lord, please come to, my lord, the bottom. On 20th December 1952, my lord, the relevant would be, my lord, Yes. Lord, 59, my lord, kindly come to 59. That would be 63, PDF 63. Lord, page 59, but a PDF would be 63. My Lord Justice Call and Justice Bhatt gets one.
Yes.
The Honorable Chief Justice, my Lord Justice Narsip. I'll just read at the foot, my Lord Shri S. Mahan.
This is relating to Hindu Marriage Act.
This is debate of Hindu. My Lord, it was simultaneously going on. Same people, same members, same provision in, my Lord, question. But your lordships are right, factually, Hindu Marriage Act.
No, 60. PDF 60 it starts.
Your lordships are reading some.
Even the dates also are similar.
Triple one.
Yeah, yes, my lord, dates are relevant. But this is 20th December 1952.
Hindu Marriage Act.
And my lord, what we read was September 54. But it was a period during which all these, my lord, legislations came.
No. As a historical fact, of course, it's the Hindu Succession Act and the Hindu Marriage Act would have been enacted by the first parliament, not, I mean,
Yes,
the
yes,
first
my lord.
parliament. The elections took place in 52. So
Correct,
this is
my lord.
provisional parliament. So when it
Correct,
when
correct.
it took place, then looking at the nature of the Hindu Marriage Act, which came in 56, perhaps this was debated when it's enacted becomes material. Maybe there was it's documented, no, historically. That the
Can I request your lordships, my lord, to see page 57 foot, the date on homosexuality. That is, my lord, 6th of September 1954. Your lordship gets, my lord?
Yes.
Yes, it's there.
No,
That
wait,
is
sorry.
homosexuality in the context of special marriage act. That's the debate which is going on. Then the next date is 16 September 54, 17 September 50, it should be 54, then 16 December 54. Then, my lord, on marriage between opposite sexes, again, my lord, 54. But if your lordship, my lord, comes to,
Why is 20th December 52 is mentioned against Hindu Marriage Act?
I think
That's not
my
the
lord,
date.
it was debated, my lord, for
Maybe.
yes, but about 2 years.
2 years.
I think that's the reason. There was a lot of discord,
Started
no?
from, must have been started from 50.
I could not hear my lord justice, but my lord.
Justice Bhatt is saying something.
I think there was a lot of
I could
discord.
not.
If I'm not wrong, there was discord about the Hindu Marriage Act. So
Yes.
perhaps the Special Marriage Act got enacted first. So the Hindu Marriage Act might have undergone a lot of debate. Ultimately, this was the point of difference between the president also, right? Which led to the Hindu.
Correct.
Lord, we'll check. I'll
Yes,
check
the
up
one
and
vote of the
respond because
president.
I don't wish to be inaccurate, my lord, in factual this thing. But if your lordship comes to 59, that is, my lord, 63, PDF 63, your lordship would find the debate dated 14th December 54. This is debate of Hindu Marriage Act, but the same provision of Lord divorce being considered.
Where do you want us to read, solicitor? Now,
Mr. Mahanti's.
Hindu Marriage
discussion.
Act, where do you want us to read?
Mr. Mahanti's discussion.
Yes, Sri S. Mahanti. Yes, sir. I shall be brief. I speak in support of the amendment number
One
135.
page.
I'm sorry, page 63 PDF.
Yes, go ahead.
At the foot, my lord. Last speaker is, my lord, Sri S. Mahanti.
Yes.
Yes, sir. I shall be brief. I speak in support of the amendment number so and so, which is a very innocuous one, namely that at page 8 for line 12 to 40, the following be substituted, namely, and by either spouse on the ground that husband or wife, as the case may be, has since the solemnization of marriage been guilty of rape, homosexuality, or bestiality. It will be apparent from the wording of this amendment, sir, that it only seeks to substitute one very obnoxious, though biblical word sodomy by word homosexuality. I can well anticipate the objection that the Honorable Minister in charge of the bill would bring forward against this amendment. He may point out that the term sodomy is one which has received wide recognition in the Indian Penal Code, and therefore we cannot substitute that word by another, namely homosexuality, however more scientific and appropriate that term may be. But I would submit that it has also to be borne in mind, I'm sorry. I would submit that it has also to be borne in mind that here we are not going to make sodomy a penal offense. Therefore, it has got no relationship whatsoever to the Indian Penal Code here. We are here discussing this question in isolation. So it has no relation whatsoever to the Indian Penal Code. Therefore, I hope my esteemed friend, the Honorable Law Minister, will have no such argument to offer while replying in me second place. There is no reason to believe that sodomy is only a masculine vice. I have not time, nor is this occasion otherwise. I could have quoted chapter and verses to show that homosexuality amongst women is also today on the increase, that it is on the rising scale. I have got whole literature on this with me. Then, my lord, they discuss. Then Mr. Mohanty says, yes, sir, I submit, instead of using the term sodomy, you should use the better and more appropriate and scientific term homosexuality. Then Sri Mohanty. But before I resume my seat, sir, I wish to urge this House not to take a Philistine attitude. I would request the Honorable Minister not to take any such prudish attitude regarding this matter. We are not moving this amendment in a sense of levity. On the contrary, if you want to contribute to the solidarity of marital life, if you want to contribute to a healthy married life, and if you consider that sodomy is one of the reasons which can render married life unhappy, then there is every reason why you should also include the feminine vice of lesbianism and substitute the word homosexuality for the word sodomy. That is my submission, sir. Then, my lord, ultimately, Dr. Karmakar, my lord, puts an end to the debate by this. As I said, for the time being, let us be content with the use of the word sodomy. If homosexuality becomes a problem, we shall face it courageously. Look, this was in the context of adding homosexuality as a ground for divorce. One was saying that homosexuality and lesbianism is on the rise. Please add it as a composite word. The minister says, let it remain sodomy. If it becomes a problem, we'll face it courageously. The purpose of, my lord, my reading the debate is that it's not as if they were not aware of other spectrum other than, my lord, conventional man and conventional woman. They discuss, initially they start with parties. Thereafter they discuss that no, it cannot be parties. It can be boy and girl. Then they define separate age for boy, separate age for girl. They were aware of homosexuality, but they consciously avoided even as a ground of divorce. May I continue tomorrow?
We'll continue tomorrow. Mr. Solicitor, what is...
Lord, I have, my lord, we have prepared, my lord, for our, on our side. Lord, I'm sorry, my lord, maybe a day, my lord, 2 sessions, my lord.
My lord,
So
yes.
if it spills over, my lord, an hour or so.
All right.
But my learned senior, my lord, Mr. Sibal is there. Learned AG is, my lord, I think learned AG wants to
Your
say
Lordships will
something.
have to tell me when I wish to need to address your Lordships. my lord.
Lord, my apologies to Justice Call and Justice, but my lord, I'm handing over the tentative timings suggested by all councils, but it's not, it's in physical form. I'll, my lord, ensure that your lordship gets it.
Solicitor, it will reach, don't worry.
Yeah, but I ensure, my lord, that it will reach. My lord, this is the period suggested by everyone. It is, of
The
course,
time we'll see how we'll best allocate. The first few council, of course, will give you a very substantial field for argument. The others, as in the case of the petitioners, will have to curtail their arguments.
My lords, yesterday, when I concluded my submissions, Honorable Justice Bhatt had asked for some documents. I just want to draw attention that I filed those this afternoon.
Yes.
obliged to, Lord.
By the governor, and the act of the governor is subject to judicial review. In these circumstances, the governor, in his ipsit dixit, guided by his political masters in mala fide, and in the teeth of the provisions of the Constitution, granted a de facto. What it does, Mullahs, what paragraph 3, when paragraph 3 is deleted, the governor by his action recognizes paragraph 3. He recognizes the split. This is not a stage where the government is to be formed. This is a stage when an elected government is running. So your lordships for the first time will have to decide what are the discretionary powers of the governor in that context. And can his discretion be used to topple a government with respect to a set of people who say they are split from the Shiv Sena, when a Shiv Sena chief minister is already in place and the governor does not ask the Shiv Sena leader as to whether you are endorsing this or not? By not asking the Shiv Sena, he is recognizing a split. No, there is no discretion after the elected government is formed. The government then will fall, Mullahs, on the floor of the House. Then the question of the discretion of the governor will come in. If there's a no confidence motion, government falls, then the question will come in as to who the governor will call. But the governor cannot by his act topple a government. No, the question is not that. When Mullahs, the governor was approached, when the governor was approached by BJP as well as Eknath Shinde, and the governor told us to have a trust vote, Mullahs, on what basis did he ask us to do that? He obviously recognized the 39, otherwise he wouldn't have asked us for a trust vote. There was no occasion to. Because they continue to be in the Shiv Sena. That's their own case. That they did not, Malads, move away from the Shiv Sena. So if they did not move away from the Shiv Sena, which is their own case, on what basis does the governor say you have a trust vote? Unless he recognizes that the 39 members are rebels, they have split from the Shiv Sena, therefore they and BJP have a majority, therefore you go and show your majority in the House and have a trust vote. That is, well, that's logical. That's the only way to look at it. And the governor must act consistent with constitutional morality. Malad. What's the moral foundation of such an act? I've already said deletion of paragraph 3. I don't have to read. Of course, it's a principle of constitutional morality. Well, then I want to just note the page, Malad, in Navam Rebia at page 1145. 1144. Paragraph 210, Malad. Just note that.
Para?
Para 210. Don't mistake the book, but just note that. I'll just read it. Last 4 lines, Malad, of that paragraph. Admittedly, the governor never called for a floor test, nor did he ever require the chief minister to establish his majority in the House. The governor's actions based on feuds and wrangles of a breakaway group which is not recognized under the 10th schedule cannot be constitutionally condescended.
What was the last sentence? The governor's? The last.
I'll just read it again. Admittedly, the governor never called for a floor test, nor did he ever require the chief minister to establish his majority in the House. The governor's actions based on feuds and wrangles of a breakaway group which is not recognized under the 10th schedule cannot be constitutionally condescended. It's directly on point. Because the governor, by asking me to go for a floor test, having a trust vote, has condescended to recognize a breakaway group, expressly prohibited and the governor's action struck down in Navam Rebia. So we don't have to go into the issue whether the matter should be sent back to the speaker or not. If you decide this issue, the matter is, nothing else is required to be decided. So we challenge the trust vote. We challenge the action of the governor to swear him in as chief minister. If that goes, everything else goes. Then we don't have to go into the problematic issue of sending disqualifications back to the speaker. And ultimately, Malad, the facts are so crystal clear that they can't be the subject of yet another interpretation. They can't be, Malad. The Constitution doesn't give him that power. The 10th schedule, he is far away, far removed from him. Para 3 has been deleted. Breakaway groups can't be recognized by that way, Malad, every day a breakaway group will be recognized by the governor and governments will fall. I don't think, Malad, the Republic expected this. And our Constitution, Malad, ever envisaged a situation that can happen in our constitutional democracy. The whole integrity of the political process comes to naught.
Rameshwar says.
MLS, Nabam says the 3 areas in which the governor has discretion, beyond that, none. 371, Article 200, and Muller's forming a government at the initial stage after an election. There is no discretion with the governor. He acts otherwise on the aid and advice of the Council of Ministers. That's settled law. And of course, 356, Mullahs, sending a report to the central government. That's not something on the aid and advice because, so 356, 200, and 371. These are the 3 areas.
Mr. Sibal, once a person incurs a disqualification
Yes.
under the 10th schedule, then the consequence under Article 193, bracket 3, is that his seat shall thereupon become vacant.
Yes.
Because 190 in terms, 193 in terms refers to 191(2),
Yes.
which refers to the 10th schedule.
That's correct.
So the seat shall thereupon become vacant. So suppose a group of MLAs, forget this case, suppose a group of MLAs incurs a disqualification by being a split, which otherwise is not recognized by the 10th schedule.
Correct.
So the strength of the House therefore falls by the extent of the disqualification.
Absolutely.
In which case the majority required for a motion of confidence would also be altered. So suppose
Yes,
in a House
yes.
of 200 members,
Yes, yes.
20 have become disqualified.
Right.
Then it would be 90 instead of 100 for the vote of confidence.
Correct.
So would the governor in such a case be justified in saying that, well, I still want a vote of confidence because assuming that these people now are disqualified, I still want to test the legitimacy of the government after excluding these persons. Can he do
Well,
that?
if the arithmetic is so stacked, Mullahs, he can, but nothing more than that.
Right.
The arithmetic is so stacked, he can.
Because the consequence is that those people have to be excluded from the House.
I agree.
The number comes down, and then he can say, well, I want
Correct. So
the
therefore,
government-
Mullahs, the arithmetic.
minus these people who are disqualified to establish that
Absolutely.
they
No dispute on that proposition, but that the arithmetic will decide.
that the arithmetical.
That's it. Here, that question doesn't arise. Yeah, we know he's made chief. You think by now the judges don't know he's been made chief minister? I don't understand. Well, your lordship is right, but then the arithmetic will decide. There's no discretion there. He'll call the chief minister. He says, these people are excluded. This is the arithmetic. This is what the numbers are. Prove your majority.
No, but then look at it this way for a moment. I mean, we are not at all on the facts here, but just to test a constitutional position, which is that, say or we can, just for the sake of clarity, the Shiv Sena has 56.
Yes, ma'am.
Or had 56 when the
55.
government was formed.
55,
Right?
I thought, Mullahs.
Oh, sorry, 55.
55.
55. Now, disqualification notices were issued to 22 plus 16, 38.
That's right.
So for a moment, for the argument, we proceed with your hypothesis that this is a split and therefore they are disqualified. Right? So then the Shiv Sena is left with 17
Yes,
if these people are to be disqualified.
yes.
So it comes down to then 17 plus NCP has how many? 44 or how much?
54.
It's 53.
53 plus 17, 70.
Yeah, I just see.
And Congress has 44, right?
Yes, 44. BJP is 106. Even then, it'll be fine.
Right. So in such a situation, would the governor be justified in saying that, look, assuming that these people have incurred a disqualification, I still call for a trust vote because the impact of these 39, at that stage, he is not deciding the disqualification. At that stage, the governor says, well, according to me as a constitutional head, it appears that these people they have split. I'm not deciding that they have split because that's the discretion of the speaker. Can the governor now not say in a given case that, look, these facts now stare at me. I postulate that these people have incurred a disqualification. I don't treat these as members of the House at all. But therefore, because these people stand excluded, and the strength of the ruling of the government then falls down to the extent of the extent of the split. I want a trust vote.
Well, let me analyze that in two ways. Number one, you can't then administer an oath of office to one of those who is disqualified.
Yeah, you're right. Absolutely correct. Your line of thinking and line of argument on this is
okay. Now let's forget that.
That we'll keep aside.
We'll keep aside. Now,
the power of the
somebody should tell the governor that constitutionally what happens, from my little experience, the numbers, if stacked against the government, will go to the governor and say that the leader of the house has lost the confidence of the house.
Right.
Then he will analyze that and call. But governor will not do this. That's not his job. There's a sitting chief minister. It's an elected government.
You're right. At that stage, the governor is not really calling upon someone else to form government. But what he can certainly do is that, well, according to me, you have a ruling party with, say, which is supported in a coalition with, say, 60 members. Out of the 60, 40, which is a split. The governor says that, well, this is a split, and this is a split which is not recognized now by the 10th schedule. The speaker is going to take his own time to decide on the disqualification. But as the constitutional head of state, I do believe that with these 40, having, contrary to the constitution, moved away, at least as a head of the state, I require a trust vote on the floor of the Legislative Assembly. That I don't believe the governor would be wrong in calling for a trust vote.
I will say it is wrong, then I'll constitutionally provide an answer.
Why would that
The moment a governor does that, take Maharashtra, there are any number of parties apart from Shiv Sena, apart from NCP, apart from Congress. There are so many small parties. Now, those small parties at the moment supporting whoever is in power. The moment the governor does that, the buying and selling will start. In fact, the governor will be inviting by his unilateral act of saying, prove your majority. There's no question of proving majority. He is the chief minister. Somebody else has to tell the governor that there is no majority. These are the signatures. These are the people who are with us. He doesn't have majority. If you allow that as a constitutional principle, it will be disastrous for democracy.
No, but the very fact that a disqualification notice has been issued initially to 16 and 22, this is not a case where the governor is sort of, finding facts, in the political spectrum. The governor is informed, the governor knows that, well, disqualification notices have been issued to 16 plus 22 or a group of persons.
Yes.
Which disqualification, the wrath of disqualification, the moment it attaches to a very sizable portion of the MLAs who are part of the ruling coalition, can the governor be said to be not justified in saying that, well, I'm not deciding the disqualification, but now please establish that you have a majority in the House, and I'll decide whether your majority depends on these 39 or your majority is safe irrespective of these 39.
Even otherwise on the arithmetic, the numbers are in favor of at that time, in favor of
because, Mr. Sibal, you are also right.
Independence of
Mr.
support.
Sibal, for the present purpose, because we still have to hear them on that aspect. So as a hypothesis, we proceed on the basis that you are right, that these 39, they had really split. That too, a split is not recognized by the 10th schedule. Therefore, they necessarily have to go out.
Right.
Asking Mr. Eknath Shinde to form the government, that's a separate issue. We'll keep that aside for a moment. We'll have to hear them on that. But as an abstract constitutional principle for the governor, what else does he do?
Let's analyze the numbers now.
Does he say that
he still has the numbers? He still has the numbers. They are only 106. There are independents, there are other parties.
No, that point is simple. That is again, because, can we say that then the governor is, you see, a lot of times what happens is the governor may have done something which is absolutely within his power, something which may run afoul of constitutional principles. But we have to we have to separate the grain from the chaff. Per se, when there is a disqualification notice moved to the speaker, in respect of a sizable group of MLAs belonging to the ruling party, How can we say that the governor is not justified in
Well,
they're going to the
because-
government saying, come on now, prove your...
When does a governor, well, we'll have to go into that question then. When does a governor call for a floor test? Then we'll have to go into that question. Has ever a governor called for a floor test on his own when there is a government in power? Never. Never in the constitutional history of India. Never. And the reason is simple. There is an elected government. He has proved his confidence on the floor of the House. There may be disqualification.
You see, because the defection has two consequences. At one level, the defection results in persons who have defected by virtue of a split, ceasing to be members of the House.
Yeah.
But that very defection, which operates to exclude them from the membership of the House, also affects the legitimacy of the government, legitimacy in the sense, the strength of the government on the floor of the House. So therefore, the very same act, which is unlawful, of a group of persons forming a split and going out of the party fold, they incur the wrath of disqualification.
That stage would have arisen if the disqualification petitions had been decided. Let's assume, Malaz, that your Lordship's example is right. But that stage will arise if the disqualification petitions are decided and they are out of the House.
No, but for that purpose, can the governor not say, well, I assume that they will be disqualified,
Well,
but
he
therefore
can't.
I need a show of strength on the floor of the House.
But the governor has to wait on the constitutional process, the outcome of the constitutional process. Governor cannot say, I'll assume this or I'll assume that. I'm sorry. I mean, this is a proposition of constitutional law, with the greatest respect,
No,
that will ultimately encourage the kind of things that are happening today and we see all around. Please. Toppling of the government should be the priority as far as the governor is concerned.
Mr. Sibal, you are saying that constitutionally, it's impermissible for the governor to take cognizance of any of those events which are all over.
Correct.
Nevertheless, he has no power to take cognizance of either the 10th schedule notices or even the earlier notices with respect to the speaker,
Correct.
or even those representations of violation of the whip and all that has happened in the papers over.
Yes.
He cannot by himself take cognizance of anything like that at
That's
all
correct.
and ask the legislator or the chief minister to prove his strength in the floor of the House.
Correct. Because they are part of the Shiv Sena. They themselves say,
We are not on Shiv Sena, we are on the power of the governor.
that's right, even then.
Power.
When an elected government is running the constitutional principle, I humbly submit is the following. If the numbers are stacked against the elected government for whatever reason, they can go to the governor and say, these are our numbers, these are how they are stacked. Governor verifies that issue, verifies the signatures. Normally, that's a practice that used to happen, but governors now say, we don't want to enter into the political thicket. But be that as it may, that may be a possibility then for the governor to say, look, I feel that you have lost majority because these people have come to us. But governor on his own can't do that. This is no power of the governor to help in toppling an elected government. Whereas you assume governors will act constitutionally, but how many times have you struck down, actions of the governor who have acted unconstitutionally? And once that happens, then everybody else will get into the act. All those independents and all those people belonging to small parties. I don't want to say anything more. So, please don't lay down a constitutional principle that will create havoc.
But Mr. Sibal, suppose in a given case,
Yes.
not in this case, the majority of the people in power, correct, we were part of the government. They, along with the other party, correct, goes to the governor and says that, sir, correct, the present government, correct, has lost the confidence. We are the persons. Correct. In that case, the government
Cannot.
Governor can. Why? Because governor has to set.
No, they are still the party, They are still in the party. It is against paragraph 3.
All right.
Because paragraph 3 doesn't recognize majority, minority.
Apropos what my learned brother said, and I remember when we were much younger, there would be that parade of MLAs before the governor.
Yes, yes, I
I don't
remember.
see that now. That used to happen in the
now it's not
1980s.
happening.
Yes.
Because that's why, my lord, is the right question, but whereas majority is now prohibited under 3. It
No,
doesn't
but
matter.
just taking the line of the reasoning which my learned brother put forth, could the governor not say that, well, I want you to demonstrate that you have your majority in the house. All right, I exclude 20 people who have in an 80-member house. I exclude the 20. I learned that there are disqualification petitions against 20 out of an 80-member house. Come before me or demonstrate to me that you still have 40 MLAs before you.
But we could have demonstrated and we would have won. If those 40 are, even if they are excluded.
So therefore, Mr. Sibal, the governor can, even you
No,
concede
Malad,
this,
I
you
don't agree
concede
with
it.
that proposition.
No, that the governor can certainly say that demonstrate to me that you have 40 out of 80 MLAs in an 80-member house.
It's nobody for the, it is not for the governor to say that. It's for those people in the house to go to the governor and say they have lost majority. It's not for the governor to enter into the
Fair enough. But suppose those people, therefore, obviously the opposition in the house would say, well, they have lost their 40. In which case, what does the governor do? At a primary level, the governor says, well, now I have learned from the opposition that you cease to have 40 out of 80, which you had originally, or say 45 out of 80, because 20 have now been issued disqualification notices, so that your strength comes from 45 to 25. Now, please, prima facie demonstrate to me that you still have 40.
Let me try and answer that.
How does the governor then
let me
proceed? What
try
does
and
the
answer
governor do in a situation
Let
like
me
this?
try and answer that. Malad's governor prima facie on the arithmetic of the house must first come to the conclusion that the leader of the house has lost the confidence of the house.
Absolutely correct.
How will he decide that? If somebody goes to him. Somebody goes to him and says, this chief minister has lost the majority, lost the confidence of the house, because
Now,
these are the numbers.
Two sets of people could go. Either the opposition would go, or even the defecting MLAs would go. I mean, they have.
No, they can't.
Why? They will say that, well,
We don't support this government.
Hypothetical examples ultimately, when and if it comes to your lordship's bullets, because we are not dealing with that situation. We're dealing with a person who has been recognized by the governor, who happens to be part of the 39, and who was given oath of office. We're only dealing with that issue. As and when that issue and some hypothetical stage comes in, we can debate that constitutional issue. But why?
But it's not hypothetical here at all. It's a live issue here. For the reason that once the governor is in possession of facts which indicate that a very substantial...
Which is the fact that indicates that he has lost the majority of the house.
That out of 55,
yes,
out of 55 MLAs, 38, there are disqualification notices issued by the ruling coalition
15
itself.
plus 50, 53 plus... We have the ex facie bullets. That's why go into numbers? Just see the fact.
All right, let's have the arithmetic.
Yes.
Shiv Sena had 55.
I don't know, but let's just see that.
Shiv Sena is 55.
Sena, we'll assume it's 50.
55. Congress had 44.
PDA page 62.
Congress is
Of convenience.
Congress kitna tha?
53.
53.
No,
Yes.
sorry, 44.
44 is Congress.
NCP is 53.
And NCP.
And Manoj, my request to your lordships, please call for the records of the governor whether he's gone through this exercise or not.
Yeah, that's the point you're making.
Well, please call for the records if that's the case.
And how much was the BJP? 10?
106.
And independents and other parties?
Yes. We would have been,
That will be about 20 odd, no?
But you will have
20.
to exclude this.
there would be 123, Manoj, halfway mark is 124, 120.
So,
Yes.
so as a result of, say, the disqualification notices which are given to 39,
Yes.
out of 152, the ruling coalition comes down to 113.
Well, first of all, only 34 residents had written to the governor, not 39.
Only 34.
Only 34.
Page 313. 34
Only,
decisions
only
wrote to the
34 wrote to the governor.
Right. So I'll
So
just.
let's
39, if you
get the arithmetic then.
if you exclude, it comes to 120.
Eighteen to 99, 70.
Yes.
246 is the house, half of it will be 123A,
Yes.
correct?
Yes.
23.
Then they'll become 126.
So,
Because then our
4 minus.
only take out 34.
How much do they have? 164?
Page 59. You get 62.
We've now got the from Mr. Sibal, 55 SS, 44 C, 53 NCP.
That's correct.
Comes to 152.
Yes.
What minus 30 now 288 is the number.
Minus 34 went to the governor.
Minus 34.
Yes.
But there were 39 disqualifications.
No, but Malaz, what went to the governor? If the governor is to look at it, then he has to look at 34, Malaz.
Certainly. So 288 minus 34.
39 were in the majority.
So 254.
287 minus 34 is
288, no?
288.
288.
288 was there.
287.
One
had
passed away, Malaz.
So 288 was 287.
Why?
One passed away.
One passed
One
away.
passed
So 287.
So 287 minus 34 is 253.
Yes.
So 253 divided by 2,
2, Malaz. 127.
127.
Yes. They don't have 127.
No, but the point is then the governor will say, if you exclude the people in respect of whom there is an allegation of defection from your side.
Yeah, 127, Malaz, in this arithmetic.
How do you have 127?
I'm telling you, Malaz, 54, 44, 15 is 113 plus 14 MLAs, independent MLAs. In small parties is 14.
No, therefore, now look.
In fact, Shiv Sena will be 21.
Mr. Sibal, look at it this way. 55 plus 44 plus 53 is 152. 152 was your strength.
Yes.
Of the basic three parties which form the government.
Yes.
From that, instead of excluding.
Plus 14, Malaz, there are who are supporting us. Why are you excluding?
Okay. Now,
They are independent supporting us.
fair enough. Now, 152 minus 34 also, if you take, you're down to 118, right?
Yes.
Which is below the 125 mark, right? Now 127 mark, below the 127 mark. Now you say you have some independents who are supporting.
There's all in supporting us.
Right? There are some independents who are supporting.
Both
There
sides
is-
had independent supporting
Now,
them. We had 11 supporting
One
them.
second now.
1 second. We're trying to look. These examples are only to see what the governor should in a situation. We are just giving.
But then how? Malaj is not just what. Did he apply his mind to this issue? Malaj, this is all very well. We are happening in a court of law. But did he apply his mind to this issue?
But Mr. Sibal, one thing which we cannot therefore discount, the governor has two responsibilities. One, the governor cannot enter into the thicket of disqualification. Two, the governor cannot do anything which seems to protect those who have incurred the wrath of disqualification. There we are with you completely. Equally, what is of concern to us is that the governor, in all these political wranglings and whatever goes on in the polity, there is a very high constitutional principle, which is that whoever is sworn in as the chief minister must ultimately have accountability to parliament and therefore to the people. Otherwise, what we'll be doing is that the defections have two consequences. The defectors have a personal consequence that they get out of the house, that their seats become vacant. But equally, we cannot gloss over the fact that the defection affects the stability of the government itself. And how does the governor, as the head of the state, ignore the consequence of...
Where is that question that arises here, Malaj? Where is that question, please? How does it arise here? How did the governor didn't look at all this, what your motives were putting to me. Ask for the records. So, Malaj, why go into a hypothetical situation, Malaj? with the greatest respect, Mullah, your lordships have so much experience. Let's not tread into areas which we are not